Good evening and welcome to Courts Today by Livelaw. This is your host Urvashi Chauhan bringing you the latest updates on the legal front. This is your go-to source for all things legal. Let us start. Starting with the update that the Supreme Court is getting 3 new judges today. Justice Satish Chandra Sharma, Justice Augustine George Massey and Justice Sandeep Mehta today took oath as judges of the Supreme Court. Chief Justice of India D.Y. Chandrachud administered the oath to them at a ceremony held in the additional complex of the Supreme Court. Earlier this week, the 5-member Supreme Court Collegium had recommended their names for elevation and the central government cleared the proposals in a prompt manner, with their appointments being officially notified today. Before their elevation, Justices Sharma, Massey and Mehta were the Chief Justices of High Courts of Delhi, Rajasthan and Guwahati respectively. With their appointment, the Supreme Court is back to its full strength of 34 judges. In December this year, Justice Sanjay Kishan Kaul is set to retire. The Supreme Court today issued a slew of directions to monitor the early disposal of pending criminal cases against members of Parliament and members of legislative assemblies. A bench comprising Chief Justice of India D.Y. Chandrachud, Justice J.B. Pardiwala and Justice Manoj Mishra was dealing with a writ petition challenging provisions of the Representation of People's Act, which restrict the term of disqualification as the period of sentence plus 6 years after release, and disqualification of government servants who are dismissed for corruption or disloyalty to 5 years from the date of such dismissal. The bench observed that it was difficult for the Supreme Court to lay down uniform guidelines applicable across the states, and so it left it to the High Courts to evolve such measures for effective monitoring of such cases. At the same time, the bench did issue certain general directions for monitoring of early disposal of pending cases. The court had previously passed a series of orders for creating special courts and to try the cases against sitting and former MPs and MLAs. And thereafter, it had been monitoring the expeditious disposal of these criminal cases. Senior advocate Vijay Hansaria, who assisted the court as amicus curiae, said that these directions would hopefully ensure that less number of convicted politicians contest elections. To read in detail about the guidelines laid down, you can visit our website at livelaw.in. The Supreme Court has adjourned the plea by former Andhra Pradesh Chief Minister N. Chandrababu Naidu for anticipatory bail in the FiberNet scam case, stating that the court is likely to deliver the judgment in Naidu's quash petition in the skill development scam case after Diwali vacations. The judgment in skill development scam case was reserved on 17th October. A bench of Justices Aniruddha Bose and Bela M. Trivedi was hearing Naidu's SLP against an order of the Andhra Pradesh High Court refusing to grant him anticipatory bail in the FiberNet scam case last month. As both the petitions have some overlapping issues, the court has directed for the FiberNet scam case to be listed on 30th November. Also, in the FiberNet scam case, the state had earlier undertaken before the court that it will not arrest Naidu during the hearing. Senior advocate Abhishek Manu Singhvi today mentioned a matter pertaining to a non-bailable warrant issued against national spokesperson of Congress Randeep Surjewala. The warrant was issued by a Varanasi special judge on 7th November, ordering Surjewala to appear before the court on 21st November in connection with a case of alleged political agitation dating back to the year 2000 when Surjewala served as a youth Congress leader. Senior advocate Singhvi, representing Surjewala, explained that the case stems from events that occurred in the year 2000 and the summons against Surjewala was issued 22 years later in August last year. Singhvi argued that the court had not provided him with the legible copies of essential documents including medical records. Accordingly, Surjewala had moved the Allahabad High Court and the High Court reserved its judgment in the matter on 30th October. However, despite the order not being out yet, non-bailable warrants were issued against him. The apex court today directed that the non-bailable warrant issued shall not be executed for the next 5 weeks. It also granted liberty to Surjewala to move the trial court with an application to quash the warrant against him in 4 weeks. And now an update on the Prime Minister Modi degree row. The Gujarat High Court today dismissed the plea filed by Chief Minister of Delhi Arvind Kejriwal seeking review of High Court's order dated 31st March, which had set aside a 2016 order of the Central Information Commission, that is CIC. As you already know, in 2016, CIC had directed the Gujarat University to provide information regarding degrees in the name of Mr. Narendra Damodar Das Modi to Delhi Chief Minister Arvind Kejriwal. The university had filed an appeal regarding this, and Gujarat High Court quashed the order of CIC. In its order, the High Court had also imposed a cost of 25,000 rupees on the Delhi Chief Minister for making a mockery of the very intent and purpose of the RTI Act. After this, Kejriwal had filed a review plea before the court, which has now been dismissed. A bench of Justice Biren Vaishnav passed the order of dismissal over a month after it reserved its verdict on 30th September. In another update, the Supreme Court is set to examine an important issue, that is, can the past service in the judicial services of another state be taken into account for purpose of benefits in the judicial service of one state? A PIL has been filed by one Ms. Neetu Nagar, a candidate serving in Delhi Judicial Service who was not permitted to appear in examination for promotion to Delhi Higher Judicial Service. The High Court had rejected her claim on the basis that she had not completed 10 years service as a judicial officer in the Delhi Judicial Service. The petitioner, who has now approached the Supreme Court, had contended, though she joined DJS in 2018, however, her past service as a civil judge with the Haryana Civil Service should be counted for the purpose of calculating the 10 years. The Delhi High Court had observed that HCS and DJS are distinct judicial services of two different states governed by different service rules and controlled by different high courts. It was also noted that the petitioner had resigned from HCS and joined another distinct service, that is DJS, on her own volition. Thus, her case would lie under simpliciter resignation rather than transfer or absorption. The court also held that permitting the petitioner to appear for the examination would amount to her bypassing other candidates and thus would disturb the seniority in the cadre. Well, now the Supreme Court has issued notice to the Delhi High Court in the SLP filed by her against the Delhi High Court order. Senior Advocate V. Giri, representing the petitioner before the top court, pointed out the communication of the Delhi High Court's Registrar General to highlight that the petitioner was permitted to carry forward her past service benefits prior to joining the Delhi Judicial Service. He also highlighted that the petitioner has performed well in the exam, securing 3rd rank in the merit list. Under these facts and circumstances, it was argued that considering petitioner as ineligible would cause her injustice, given that including HCS, she has completed 10 years of service. The Madras High Court today upheld the validity of Tamil Nadu Prohibition of Online Gambling and Regulation of Online Games Act of 2022. The court, however, added that the act would not be applicable to games like Rummy and poker, which were games of skill, and would be applicable only against games of chance. Thus, the bench of Chief Justice S.V. Gangapurwala and Justice P.D. Odikesavulu partly allowed the application filed by the online gaming companies challenging the act. The companies had sought to quash the act as being unconstitutional and violative of their fundamental rights. The companies had also sought for an interim stay on the operation of the act and requested that no coercive steps be taken till the disposal of the petitions. The court held that while it could not allow the prayer to set aside the act in its entirety, the provisions of the act should be restricted to games of chance. The court added that games like Rummy and poker were games of skill, and thus the provisions of the act would not be applicable to these games. And that while the government could regulate the games by restricting the time spent playing the game, setting age limits, etc. on both games of skill and chance, it could not totally ban games of skill. And lastly, the Karnataka High Court has suggested the state government to issue a circular directing private bus operators to install audio announcement system service in their buses, which would be of assistance to physically challenged and visually impaired persons. A PIL had been moved by a visually impaired person, arguing that initially transport modes such as KSRTC, BMTC buses as well as metro lines had the facility of audio announcements, helping the visually impaired persons to know the stops or the destinations. He claimed that the abrupt stoppage in this audio system had caused difficulty to visually impaired persons. He pointed to the court that in neighboring states like Maharashtra, Telangana and Andhra Pradesh, the facility of audio announcement was functional in all major modes of transport, that is metro line and city buses and state transport corporation buses. Similarly, so far as private transport operators like Ola and Uber were concerned, the facility of Google Maps is available with passenger and with driver of vehicles. So with the coordination, the passenger seeks necessary information and exchanges it with driver, or in case of difficulty, seeks further assistance from the driver. Accordingly, the court directed the state government to issue necessary circulars to all the private operators to provide such facilities. The court directed the petitioner to submit a representation to the BMTC and state government, suggesting them to make the mobile application used by commuters disabled friendly. The bench adjourned the hearing by 4 weeks and directed BMTC and the state government to file additional affidavits enumerating the steps taken by them. I hope you found this video informative and enjoyable. If you did, please consider giving it a thumbs up and sharing it with your friends. Don't forget to subscribe and hit that notification bell so you won't miss any of our future content. You can also support us by donating through the thanks button at the bottom of our videos, or consider becoming a member at just 89 rupees per month.